Okay. Blissful morning, dear everyone. Dear the Honorable, the Business Law Lecturer, Sir Lutfi Firdaus SAMM. We are from Group 4. We're going to present about our discussion regarding the topic of commercial banks. For this case, we are separated into two teams. The one we are going to talk about is the national case about commercial bank, going to present it by me, Michelle Nishana, and my colleague.
My name is Dinuranti Karisma Putri.
My name is Diala Trigarin.
My name is Khairo Diataya.
My name is Faris Alperi.
My name is Azaria Nabila.
And we are going to start from the national case. Before going to the case, we are going to generally explain about the commercial banks. Commercial bank is a bank that provides services such as making business loan, accepting deposit, offer basic investment product. Mostly deals with deposit, loan from corporation and large business. Banks are well regulated by RBI and monitored by RBI members about how they are organized and also the service they are provided. RBI provides a unique IFSC code to differentiate each and every branch of all banks.
Okay, the next one is what are the functions of a commercial bank? Apart from this, there are so many functions that are performed by bank. The first one is accepting deposit, providing loan, investment of funds, and overdraft agency function. But the main function of bank is allowing people to deposit and provide them loan.
Now we are going to talk about types of deposit. First thing is the more important function of commercial banks like the Bank of India branches is allowing people to deposit. According to needs and economic status, they are maintaining saving with the banks. Type of deposit in Indonesia. There are terms deposit, automatic rollover deposit, on-call deposit, and certificate of deposit.
Agency function and miscellaneous. Bank collects draft, bills of exchange, checks, and dividends share for their customer. Banks also make the payment for the clients at time exchange is accepted. Bank also pays the insurance premium of their customer. Banks arrange lockers to safeguard customer silver, gold, and legal documents. Bank issue letter of credit. Banks undertake to purchase and sell foreign exchange.
The next one is providing loans. The next important function of commercial bank is to providing loan for the customer. Banks charge interest for the borrower, and then in modern bank, at the time of advancing loan, they demand proper security. There are general types of loan from bank. There are cash credits, demand loans, and short-term loans.
Next one is investment over funds and overdraft. Bank invest their fund in the three types of securities. There are government securities, other approved securities, and other securities. Government securities include both state and central governments, such as National Savings Certificate, Treasury bills, and etc. Overdraft, advance loan amount to the customer is for a certain amount. When it exists, bank will demand security from the customer and charge high interest.
And right now we are going to explain the case we choose for this material. So this case started when Miss Endang Aryani as the plaintiff sued her ex-husband, Mr. Sabto Hardoyo, because her land and building, hereinafter referred as the disposed object, which she claimed as her rightful ownership, were used as the collateral for a housing loan or KPR facilitated by Bank Mandiri. Mr. Sabto was unable to repay the debt and was declared indefault by Bank Mandiri, resulting in the plaintiff's land and building being declared for an auction as means of the debt redemption for Mr. Sabto. The plaintiff feels aggrieved by the action of Mr. Sabto and Bank Mandiri, as she claimed to have never received any warning letters regarding the sale of the collateral, nor has she ever received a notice of the auction sale of the disposed object. Therefore, the plaintiff feels the disadvantage based on the following 3 points. The first, the collateral owner has never received a notice of the auction sale of the disputed object. And the second one, the collateral owner has never been involved in any negotiation regarding the price limit of the dispute object. And the third one, the collateral object owner has not been given the opportunity to sell the dispatched object herself.
Therefore, in her lawsuit letter dated March 20, 2017, registered at the Soraka District Court on March 20, 2017, with case register number 64, the plaintiff choose four parties. The first one is Sabto Hardoyo as defendant 1, PT Bank Mandiri Persero Tbk Solo Branch as defendant 2, Minister of Finance of the Republic of Indonesia, Minister of Finance, Directorate General of State Asset, Regional Office, Surakarta State Assets and Auction Services Office as Defendant 3, Surakarta Land Office as co-defendant. The plaintiff requests the Minister of Finance to postpone the auction proceedings as they have not been involved in any negotiation to determine the price limit, have not been given to the opportunity to sell the collateral themselves, and have not received a copy of or photocopy of the auction notification letter as stipulated in the technical guidelines for auction implementation in the specific auction requirement documents. However, defendant 2 presents evidence that they have sent warning letters to the registered address during the KPR loan application process, accompanied by supporting evidence. The plaintiff and defendant 1, decided to divorce in November 2016 and did not inform defendant 2 about the plaintiff's change of address. When entering into the credit agreement, defendant 1 as the debtor obtained the plaintiff's approval with evidence of the plaintiff's signature as the owner of the disputed object.
For the legal basis, defendant 2, responding to the issue raised by the plaintiff, defendant 2 has the following legal basis. First one is Article 6 of Law Number 4 of 1996 concerning mortgage right on land and related object regulates. If the debtor breaches the agreement, the first holder of the mortgage right has the right to sell the subject to of the mortgage right on their own through a public auction and obtain repayment of their debt from the proceeds of the sale. The limit value itself has been determined in Article 44, paragraphs 1, 2, and 3, as well as Article 45 of Minister of Finance Regulation number 26, PMK 27, PMK 6, 2016, which states Article 44, paragraphs 1, 2, and 3. The first one is the seller established the limit value based on A, appraisal by an appraiser, or B, estimation by an estimator. The appraiser referred to in paragraph 1. Point A is an independent party who conducts an assessment based on their competence. Third is the estimator referred to in paragraph 1. Point B is a party or organization from the seller who conducts an estimation based on a method that can be justified by the seller, including curators for art and antique objects.
Article 45, the limit value is determined by the seller based on the appraisal result from the appraiser in the case of A, non-execution voluntary auction of goods in the form of land and or buildings with a minimum limit value of 1 billion Indonesian rupiah. B, execution auction as stipulated in Article 6 of the Mortgage Law, fiduciary execution auction, and bankruptcy asset execution auction with a minimum limit value of 1 billion Indonesian rupiah. C, the creditor bank will participate in the execution auction as stipulated in Article 6 of the Mortgage Law or fiduciary execution auction. In the credit agreement, it is stipulated regarding the rights held by defendant 2 when there is a default by defendant 1 as regulated in Chapter 5, points B and C of the credit agreement, Article 13.1.1 and 13.2 and Article 14.6 SUPK as follows. Chapter 5, point B of the credit agreement. B, if the debtor has failed to make installment payments according to the provision in this credit agreement or in the event of default stipulated in the general terms and conditions of the consumer credit agreement of PT Bank Mandiri Persero Tbk, Then the bank has the right to declare the entire outstanding amount due to and payable by the debtor immediately and in full for the bank's initial claim. And the bank might exercise its right over the collateral provided by the debtor or collateral owner to the bank based on this credit agreement. Article 13.1.1 and 13.2 SUPK state 13.1 the term default in the credit agreement and general terms and condition refers to 13.1.1 if in the bank opinion the debtor heirs has failed to pay or paid less than the specified amount at the due date of an installment for the repayment of the credit facility or outstanding amount in accordance with the terms in the credit agreement and general terms and condition, in which case the mere passage of the time sufficient evidence of the debtor negligence and there is no need for a reminder to similar letter as a proof such as negligence. Supreme Court of the Republic of Indonesia.
Article 13.1.2, in the event of a default as stipulated in Article 13.1 of this general terms and condition, the bank has the right to immediately and unilaterally declare the entire outstanding amount due and payable, and the entire outstanding amount must be paid by the debtor immediately and in full for the bank's initial claim. Therefore, Defendant 2 has the right and authority to conduct the auction as described in the above-mentioned articles. The result is plaintiff's claim is rejected. Defendant 2's objection is accepted because the mediation for the parties are succeed done on 2021 and the first parties with the lawsuits. So I think that's all for the case in Indonesia, and we're going to continue to the case for international.
Okay, now me and Faris and Cairo will explain about the international case that our groups will discuss. And next page, please. So the agenda of the presentation is to first to us to get to know the Danske banks and the case, the fundamental of the case, and the final verdict.
Okay, since the previous team has explained what a bank is and what it does, we just jump in directly to the case. So the case began in 2017 when the Estonian financial regulator informed the bank of suspicious transactions involving its Estonian branch. Danske Bank initiated internal investigation to identify the extent of the problem, individuals involved, and potential damage. Media reports and subsequent public awareness led to regulatory involvement with various financial regulators and law enforcement agencies conducting their investigations. The investigations revealed that the fraud scheme involved vast amounts of suspicious transactions linked to non-resident clients, particularly from Russia and other countries. The case attracted international attention, leading to cooperation among various financial regulators and law enforcement agencies. It's important to note that the case beginning and subsequent developments are subject to ongoing investigation, legal proceedings, and regulatory actions. Therefore, for the most up-to-date and comprehensive information on the case beginning, it is recommended to refer to the reliable news sources, official reports, and legal publications that provide in-depth coverage of the Danske Bank fraud scheme. Thank you.
So for the fundamental law that are violated in this case, it would depend on the jurisdiction in which the fraud occurred and the specific details of the case. But however, here are some general laws and the articles that are commonly associated with the fraud cases. And the first one is the anti-money laundering laws, AML, and various countries have enacted legislations related to anti-money laundering, such as USA Patriot Act in the United States, the Proceeds of Crime Act in the UK, and the EU Anti-Money Laundering Directive. Specific articles may vary, but common provisions include requirements of the banks to establish and maintain the effective AML programs, conduct customer due diligence, report suspicions, transaction, and monitor high-risk accounts. And the second one is fraud and misrepresentation laws. And the fraudulent activities involve intentional deceptions for financial gain. And the laws is related to fraud and misrepresentation may encompass different elements, such as false statement, deceit, concealment, and unauthorized use of funds. These laws can vary across jurisdictions, and specific articles may differ accordingly. And the third one is securities law. And if the fraud involves the securities, various laws may be relevant, such as Securities Act of 1933 and the Securities Exchange Act of 1934 in the United States. These laws regulate the issuance, trading, and reporting of securities and impose penalties for fraudulent activities related to securities. Next one, please. And next, the banking and financial regulations. The banks are subject to specific regulations that govern their options and conduct. Violations of regulation pertaining to risk management, internal controls, customer protection, and reporting the obligations may be relevant in fraud case. And the last one is the conspiracy and racketeering laws. In some instances, criminal charges related to conspiracy, racketeering, or organized crime that may be applicable if multiple individuals or entities colluded to commit fraud.
Okay, so I'm going to tell you the final of this case. So what's happened with Danske Bank? Danske Bank. So first we know that Danske Bank was pleaded guilty and was found guilty by money laundering and suspicious transaction. So Danske Bank was charged to forfeit for around $2 billion. And then Danske Bank has to implement significant change to its compliance and AML, the anti-money laundering. So what's happened next is Danske Bank was monitored under the US bank. So they have to keep providing information related to anti-money laundering and even the transaction with the customer. Okay, next. And so that's the end from for the presentation from the international case. And we're going back to the host now.
Okay, thank you everyone for the explanation regarding the case of national case and international case. We are from group 4, we're signed out, and we're really looking for your feedback regarding of this case.
Yes, I think that's all from us, and thank you so much for listening and paying attention. Wassalamualaikum warahmatullahi wabarakatuh.